Good afternoon. Welcome to Cannabis Live. I'm Travis Copenhaver. I'm here today with Galendez.
Hi.
Today we're going to be discussing a new program announced yesterday called the Industrial Hemp Agricultural Pilot Program. We're going to go over briefly how that program is going to work, things to expect, and ways you can start participating if you are interested in being a license holder to cultivate industrial hemp. But before we get into that, Nick is going to give us a rundown of this week's news.
Thank you, Travis. Today in this week's Cannabis News, we just wanted to provide you with a few updates on previous news that we talked about with some bills and legislative action. Another update on the temporary operator litigation going on right now in the Court of Claims, as well as a little fun research study that opened up more recently talking about the munchies. So first off, just to Travis likes the munchies, so we're gonna go into that last. But first, officially now, Senate Bill 203 was signed by Governor Whitmer. That was the bill, if you recall, from last week and previous episodes that basically corrected the application process for applicants under the MMFLA. Previously, there was a correction that allowed less than 10% owners to go through a more abbreviated disclosure process and not have to go through the full vetting process, according to Laura. And then there was some readjustments related to industrial hemp where that language was not corrected. So this bill, Senate Bill 203, officially corrects that language and now officially makes those changes 100% complete, such that now there's more of a 10% threshold as compared to before, and there will be a little bit more relaxed ways for applicants to apply.
Right. It's all a complicated way of saying there was a new rule put in place that created this 10% threshold for disclosures, while other bills were pending relying on the old language. And the way these bills got passed at the end of last year is we changed the definition of applicant for the MMFLA. One of the other bills that passed afterwards changed it back, and this is a bill just correcting the course forward. You know, the intention was for that new 10% threshold rule to be in place. That's what Senate Bill 203 is doing.
Mm-hmm. So up next is updates on temporary operation litigation and House Bill 4440. As far as the updates on the House bill, that did basically House Bill 4440 is going to put penalties in place for those facilities that are holding themselves out to be existing facilities or obtain their license in bad faith. And so what that potential new law says is that if you are one of these types of facilities, you are ineligible to apply for a state operating license for a year. What happened was the House voted 102-4 in favor of these changes, and the bill now is going to go to the Senate for potential changes or revisions and a vote. If there's any potential changes, it has to go back to the House, back to the Senate. There needs to be one bill reconciled, and then it goes to the governor's desk, and she gets to determine whether or not to sign that. We'll keep you posted on the updates on that. In terms of temporary operator litigation, there was a case filed in the Court of Claims, and a temporary restraining order was placed, allowing temporary operating facilities to remain open for the time being. Court of Claims Judge Borrello did hear arguments from both sides, and there were some comments. He was quoted, not blaming but criticizing legislators for potentially not acting timely in order to correct these issues, which then led to the department to have to make these kind of moving deadlines and keep changing things back and forth. So we're going to wait for the official ruling from Judge Borrello, which is anticipated to be a week from now, and we can continue to keep you updated on those matters.
Right, and we have effectively, the next week before officially something's going to change. So the temporary restraining order that was previously put in place after the last hearing continues forward until we get the final ruling from the judge. Mm-hmm. So keep posted. We'll be talking about it next week, I'm sure.
We keep talking and not talking about it. So it's always been a moving target, and we'll continue to keep you updated on that. Last but not least, Michigan State University released a recent study that had to do with the munchies. And so, as you know, there's a stereotype kind of in the cannabis industry, in the cannabis world, that smoking cannabis gives you the munchies. You think of the typical kind of stoner stereotype with a bag of Cheetos or Doritos, just kind of chowing down on food. And so What this study says is funded by the National Institutes of Health and published in the International Journal of Epidemiology, basically examined users and non-users of cannabis as it relates to hunger and I guess binging and purging on food when they're high on cannabis. And so it studied 33,000 adults over 3 years. All of them, unfortunately, showed a weight increase over 3 years, so I guess that's not a good thing to think about with the passage of time. But basically, compared to users versus non-users of cannabis over a 3-year period, it actually interestingly found that the users of cannabis had less of a weight increase than non-users. And so I'm not sure what that means. Obviously, with a lot of these studies, there's a lot of things that these researchers don't answer. But I think what it kind of sheds a light on is not to take stereotypes at face value. There's a lot of differences between correlation and causation. And certainly as it relates to cannabis across the board, there's a lot of need for further research into not only these fun topics such as do cannabis users actually get the munchies and get high over a period of time and gain more weight than non-users, but also certainly for more medical purposes and for potential public policy questions we might have. There definitely needs to be further research on cannabis in the future.
Certainly. So that pretty much wraps it up for some of the news stories we want to talk about this week. And probably the biggest item of news as it relates to cannabis and cannabis-related issues such as hemp would be the pilot program announced by Governor Whitmer yesterday. So basically, the Department of Agricultural and Rural Development, or what we call MDAR, is going to be accepting applicants to engage in a program called the Ag Pilot Program for industrial hemp. Effectively, while we previously discussed changes under the 2018 Farm Bill that's going to allow federally and in the state of Michigan a way to engage in the industrial hemp industry commercially, we still have the 2014 Farm Bill. The way the 2014 Farm Bill works is it allows the limited cultivation of industrial hemp for research and educational purposes. And because the state of Michigan is one of the states leading the charge in getting ready to participate in the 2018 Farm Bill, they're basically using what they're allowed to do under the 2014 Farm Bill to put the foundation together, and that's what this pilot program is all about. We're talking about the Ag Pilot Program for industrial hemp. Nick and I are going to give you an overview of what industrial hemp is and what this opportunity is here in Michigan. So what we had tried to ask before we lost some audio there for a second is what exactly is industrial hemp? So Nick, what is industrial hemp?
So industrial hemp and marijuana, as you think about it, are conceptually the same plant. If you imagine both Travis and my coffee cup, they're both made out of the same material, they both have the same logo, they're both Cannabis Legal Group cups. But what the government's done as a matter of public policy and politics is said that my coffee cup has more coffee in it and Travis's has less. And they've made a distinction legally to treat my coffee cup differently than Travis's coffee cup. So that's where we stand with marijuana and industrial hemp. They are both a cannabis plant, but they're treated very differently under both federal, state, and local laws.
Right, and that distinction is based primarily on the amount of THC per dry weight. Basically, when you take stock of a industrial hemp product, if it has less than 0.3% THC, and when it's in its dry weight form, it is considered industrial hemp. Any hemp product that has more than 0.3% THC by dry weight is considered cannabis and is still a controlled substance. That is the huge change that was made by the 2018 Farm Bill. And since there's now a distinction between industrial hemp and other forms of cannabis, industrial hemp, when cultivated pursuant to the 2018 Farm Bill's rules, and previously the 2014 Farm Bill retroactively, is not considered a controlled substance, which means if you're taking the legal path towards engaging in the industrial hemp industry, you are not going to face the same struggles that other cannabis companies and cannabis industry operators are, because industrial hemp is not a controlled substance and therefore not illegal under the scope of federal law. Industrial hemp will be able to participate in federal programs, in banking, in funding, in all kinds of things. So the way the 2018 Farm Bill works, as we mentioned previously before we lost audio for a moment, is it is a program where the regulations are going to effectively flow through the USDA. Right? The United States Department of Agriculture is the primary regulator for the industrial hemp industry under the 2018 Farm Bill, and it shares regulatory duties with the state-level agricultural departments. And what's currently happening under that law is each state has the opportunity to design and implement a program for approval to the USDA. So that is all for the commercial aspect of the industrial hemp industry. But the 2014 draft of the Farm Bill, the previous Farm Bill before we made this change, allowed for educational research industrial hemp activity. And that is what our new pilot program that the state of Michigan is basically taking advantage of. They are allowing the hemp industry to get their start under this pilot program and operate as educational operations in anticipation of and helping the state of Michigan implement what will eventually be a commercial industry. Right?
And I think that's why that's the big news that was announced yesterday. Based on the state's powers under the 2014 Farm Bill, it was kind of left open-ended as far as how could potential individuals and companies kind of become part of this program. Knowing the 2018 Farm Bill needed some work to be done and the state programs needed to be certified by the USDA. So without being a college or university, how could those individuals actually participate? And the way that the announcement and the kind of framework is set up is that, and Travis and I are going to really dig into this coming next, is that they are going to allow certain individuals and companies to do research through and on behalf of MDARD as part of its pilot ag program. And so you will be necessarily doing that on behalf of one of those two, either colleges or universities or MDARD, in this case it's MDARD, and doing it through them and actually being able to comply with the 2014 Farm Bill.
Right, and what this really is a test run. It's an ability under the limited scope of the 2014's ability to run an educational research type industrial hemp operation to assist the state of Michigan in figuring out how it wants to work with hemp at a regulatory and basically department level. So while this is just a first step, it's an important first step and one that I think Michigan might be one of the few states to even be doing anything like this. It's very unique to and great that the state of Michigan is really taking industrial hemp by the reins. But effectively what you're doing is you would be considered a researcher. So if you were selected to be one of the applicants that are selected to participate in this program, you would be growing industrial hemp for research purposes with a relationship with MDARD, or the Michigan Department of Agricultural and Rural Development. I'm going to totally mess that up, so MDARD it is. And while you don't have to work with MDARD, previously, since the 2014 Farm Bill, you could have worked with an institute of higher learning, namely a university or something. The state of Michigan, as a body of government, could have been allowing operators to be researchers under the scope of that law. It just hadn't been doing so. So now MDARD is effectively putting the call out there to find people interested in cultivating industrial hemp, to find people who are interested in working through this pilot program to really get the ball rolling. And I'm sure most of you can assume that getting your roots in the ground and building a foundation under this pilot program are really going to help implement your ability to shift gears into what will eventually be the commercial program under the 2018 Farm Bill, when that eventually goes through the notice and comment rulemaking process needed to truly roll out that system. So that's kind of big picture. Let's talk about what's happening, because there are meetings coming up as early as April 23rd for people to submit applications. And we talk about applications a lot on our show. The type of application we're specifically going to be referring to when we say application here is the industrial hemp application under the Ag Pilot Program for this industrial hemp pilot program. That's a wordful.
Yes.
And don't let applications scare you, because we go really into depth on what an MMFLA application looks like, what we're anticipating an adult use operator license application to look like. While there is still application reporting requirements under this pilot program, the order of scale and the amount of work you'll need to do to truly qualify for this is going to be much more approachable for your average group of operators. So let's kind of talk about what these licenses are, and then we can maybe talk about how you potentially apply for one.
Yeah, and I definitely think too, as true to what Travis was saying, that right now this is a test run. They're providing the training wheels, and they're saying we want to test this out. We want to make sure that this framework works while we're promulgating those rules and the actual structure and framework for the more permanent program. And so to go with that, the application potentially is a lot less stringent. Again, we're talking about a federally legal substance and plant here compared to one that's still a controlled substance, even though the coffee cups, so to speak, are the same. So right now there's two types of licenses. It's a grower registration and a processor handler license. And there are two different kind of, there's many different types of conduct that you could do while you're researching industrial hemp. And depending on what you want to do, you're going to have to either get one or both of these types of licenses. And so Travis can kind of go into the requirements of the grower and processor licenses a little bit, or processor handler licenses a little bit, and then we can actually talk about the structure that MDARD set up that's starting next week for these potential individuals and companies to be able to actually participate in this research program.
Right, and remember, this is all currently under the scope of research and education, right? While it is very much a foundation for what will eventually be an industrial hemp commercial industry, these licenses, because they need to, are implying that this initial entry into the industrial hemp is for research purposes. So a grower applicant, basically, or a grower registration, I think it's referred to as, allows you to plant, to grow, to cultivate, to harvest the plants, to seek hemp seeds and things of that nature. But that's pretty much what it's limited to. The processor handler license allows you to then do more with the product that you've harvested. It allows you to process it, convert it into other materials, allows you to handle it, store it, transport it, allows you to be a broker effectively, and move product from point A to point B and put deals together for that, and eventually allows you to promote and sell that commodity in a limited capacity under the scale of research.
So basically what you're saying is that if I want to grow hemp, I get a grower registration. If I want to do basically anything else with the plant, all the way from processing it into some other oils or substances or topicals, if I want to try to sell or market those topicals to a third party, to a wholesaler, or if I actually want to be the company providing this to the public, presumably, I need a processor handler license and not just a grower license.
Yep, so it's pretty streamlined. It's the grower registration lets you grow the plant and harvest the plant, and then everything else is under the scope of the processor handler license. And for anyone who is watching our videos as a Medical Marijuana Facilities Licensing Act, either hopeful or license holder or in the queue, just be advised that both the safety compliance facility and the processor license allows you to take in, manipulate, and process industrial hemp products without having to obtain this additional license. So there is an exception if you're a licensed processor or a licensed safety compliance facility. I know there's not very many of you out there, but if you ever have the hopes to become a processor, you're not going to have to do this additional licensure to be able to handle industrial hemp. The state of Michigan's allowing that to fall under the scope of those two license types. So let's talk about, like, how do you become one of these? Let's talk about the grow first. I think that's probably the most accessible for most people. So what do you do? I want to be one of these grow registration pilot program applicants. Like, what do I do?
Well, all it is right now, and there's kind of a sequence of events that you have to do. So right now what you have to do is go to the MDARD website. They have a link and they have a bunch of dates falling next week where you can call their customer service center, reserve a spot, and they're basically going to put you through a few different kind of training sessions or a few different stations at that particular meeting that you've reserved to go over your research plan, to go over the application that you have to fill out with certain different parts of information, including a map, contact information, information about your business, whether or not any of the individuals, 10% or more, have any disqualifying felony drug convictions within the next 10 years. But other than that kind of basic surface level information, especially compared to the MMFLA process, as Travis kind of alluded to, it's very, very, very simple. It's, I think, about a page and a quarter to 2 pages long of an actual application for both the growers and the processor handler applications. So in terms of a heavy lift, it's a lot less, especially given the time frame for when MDARD is expecting these applications to be prepared. But basically, the first step is to reserve a spot between one of the 4 days next week where you can actually go and attend one of these registration events, these licensing events, and have MDARD go through with you all of the necessary requirements that you need to have done in order to have that research agreement signed, to get your registration or your license, and actually start being able to participate in the program.
Yeah, and the requirements are very straightforward. You need a map of where you're proposing to do this. You need a check or money order with the application fee. Those application fees compared to the MMFLA, very reasonable. I believe it's $100 for a grower, and it's what, $1,200 or something.
$1,350.
$1,350 for the processor handler. You need a copy of what's called an ICHAT, or an Internet Criminal History Report. You can get one of those from the state of Michigan. That's the basic Michigan background check to show that you don't have a felony. Now remember, you can't have a felony in other jurisdictions either. So if you do have a felony in the last 10 years from another state, while the state of Michigan is only asking that you bring an ICHAT, that's only looking at Michigan. So you can't participate if you have a felony in the last 10 years. Doesn't matter where you had it. And then the final person is, if you're not applying as a human individual, you will need to bring a few more additional information about the company you'll be applying as. But it's pretty much as simple as that. There's additional application materials you'll need to review and sign. There's a research agreement that you would, if you're selected, be entering into with MDARD. But in scope and scale, this is a very accessible application for I'd assume most people that have the means of cultivating a plant in general. So if it's something you're interested in, go to MDARD's website. We'll make sure that the link's shared in our Facebook comments here. And the steps and the processes are very straightforward. If you have a place that you could grow something outdoors, you probably can qualify. If you'd like to have someone go over that application and discuss with you, we'd be more than happy to do so. But we could very comfortably do so in the scope of just an hour-long consultation. We're talking about a very straightforward application here, which means if you want to do this, there's really no reason not to try. Now, the timeline and the turnaround time for applying to MDARD is very quick. Like I said, the first meeting's on the 23rd, the last meeting's on April 30th. So it's something you're going to need to do very quickly here. But if you want to be in the industrial hemp market, this won't be your only point of entry, but it's going to be a very easy one. Now, we have no idea what the selection criteria is going to be for MDARD. We don't know how many pilot program applicants they're going to accept. So there's obviously no guarantee that if you submit one of these applications, you'll be able to take it to the next step. But if you have the desire to do this, this is certainly an opportunity that's for you.
So I think we can very simply walk through the process. Let's say Travis and I wanted to be a grower and a processor handler. So we would call MDARD and schedule an appointment, say for Tuesday, Wednesday next week. What we do then is complete the grower and processor handler license applications. They would want to know who we are, what our percentages of ownership are, where we're going to be growing the industrial hemp. We'd want the GPS coordinates, the map of the location, similar information like that. We need to sign an acknowledgement on both applications, and we need to provide the application fees. We need to provide our ICHAT showing that neither of us have any of those disqualifying criminal histories, and then we'd be set with that. In addition to that, before the meeting, we'd also have to complete what's called the pilot program application, which is almost the same as those two other applications. It also requires a brief research plan saying, I want to cultivate hemp for this reason and assist in research for these reasons. And they also ask for any other type of experience that you've had with any other state's pilot program. In addition to so basically there are a total of potentially 3 applications that you need to fill out and have information for prior to this meeting. In addition to that, they also want you to review this sample research agreement, which kind of contains the terms and conditions that you're going to be signing up for, making sure you understand the rules and regulations that you're going to be signing up to do.
Reminding you that this is under the scope of research. You shouldn't be anticipating a commercial operation yet. But like I said previously, foundation for what could eventually become a commercial industry, of course.
And so I looked through the research agreement. It's pretty basic. It tells you about how if there is a cannabis plant that's over 0.3%, it needs to be destroyed. So this shouldn't be thought of as a way to try to, sneakily grow cannabis under the guise of industrial hemp. You can't interplant the industrial hemp crop in with other kinds of plants. Any kind of changes would need to be approved by MDARD. So they want you to review that so that when you're at the actual licensing event, you have all the applications needed for whatever license type and conduct you're trying to do, your maps, the application fee, the payment. You have already reviewed the sample research agreement, and you know what its contents are. And basically at the licensing event next week, they're going to go over all of this with all of the potential applicants. They're going to issue temporary registrations and licenses and have you sign the research agreement. And afterwards, then you'll get to go and grow hemp and do that for industrial and agricultural and educational purposes. other than that, it's a piece of cake. Short time frame,
super easy,
just
I'm
like
sure.
that, and then it's over with. But
So what can we expect? Like, obviously, if you are selected, or if there's some multiple stages of selection, it's not going to be just as simple as you're selected, you get to do this. There's going to be additional approvals you're going to need to get. There's going to perhaps be some restrictions and criteria that you would need to implement should you move forward with the pilot program. Obviously, this is a fairly new pilot program, so a lot of that might not even be set in stone yet. And I'm certain that as the state of Michigan continues forward under this program, more and more of that will come to light. But from what we're seeing and what we're hearing, this is probably your best bet to really break into the industrial hemp industry in Michigan today. And I'd encourage everyone interested in doing so to do so. And if you miss the timeline, it won't be your only opportunity. There are other efforts to expand and explore industrial hemp. I know that there's some rumblings of there being a GAMP review of industrial hemp that would be, what is that, generally accepted and
agricultural manufacturing.
Yeah. Best practices, basically. So there's efforts to include industrial hemp and create a GAMP for it. That may or may not lead to the path of including industrial hemp under our right to farm privileges. And as you'll see, given that industrial hemp is no longer federally illegal, there's still certainly quite a lot of restrictions in place on how you get to a point where you can cultivate legally. But because that federal law has changed, the ability for a government like the state of Michigan to do this, it makes it so much easier, and you'll see programs roll out at such a much more expedited fashion, as compared to, say, the adult use program for marijuana or the Medical Marijuana Facilities Licensing Act program. And what we can really look to here is, whenever a law changes, nothing's going to happen immediately. But because industrial hemp is considered no longer to be federally illegal, we have the ability for a program like this to get up and running, and we'll likely see the industrial hemp industry, really be a more viable and self-sustaining industry well before medical and adult use can catch up, just given the government bureaucracy, federally illegal cannabis needs to jump through. So it's very promising. Industrial hemp is going to continue to evolve and expand, and we'll continue to be reporting on it. Let's talk about some things that, while this is all exciting and you're going to be hearing industrial hemp in the news a lot, what are some things that aren't changing? Like, let's talk about CBD. Industrial hemp and CBD go hand in hand. Let's talk about what this will have as an impact on CBD.
Sure. So right now, again, we have the Facility Licensing Act framework. We're going to have industrial hemp framework for research purposes, at least right now. But as far as the actual sale and processing and cultivation, CBD oil is still, depending on where it's derived from, considered a controlled substance or not a controlled substance. If CBD oil is below that 0.3 THC threshold, it's not going to be regulated like marijuana or marijuana products. However, there's still the requirement, especially if you're talking about adding it to a food or a drink or marketing it as a dietary supplement, where there are many other laws. The USDA needs to approve it as generally accepted as safe for its intended use. The Michigan food law also comes into the factor if you're talking about it actually being a food product. So in terms of where this is sold, and I think people come to me countless times and say, all the other stores are selling it, why can't I? And that's exactly why. There's whole hemp seeds, hemp seed oil. There's a few things that have been generally accepted as safe for its intended use by the FDA, but not CBD oil as of right now. And any kind of substance or sale of that would only, especially if it's 0.3 or above, would need to happen at a licensed kind of process, licensed grower, licensed processor, licensed provisioning center for CBD oil over 0.3%. And then under that, it's just not regulated enough, and no one's a processor handler right now. So you can't market that product to the general public without that license. Right. So there's avenues for legality and these products to exist, but there needs to be a lot of red tape and approvals that happen prior to that happening. So if you want to do things legally in the right way, there's a lot of steps need to happen before that actually can take place.
Right, and obviously no one wants to hear that, but there are ways CBD is entering into the market, flowing through states with more robust and more mature marijuana markets. Colorado's, California's, Washington's, Michigan will eventually potentially have that opportunity as well. But what we're seeing now is a transition under federal law for industrial hemp. And another impact that's going to have is its impact on Michigan's other marijuana-related laws. So then we have the Marijuana Regulation and Taxation of Marijuana Act. We have the Medical Marijuana Facilities Licensing Act. We have the Medical Marijuana Act. So there's going to be some interaction, as we've already seen anticipated, between allowing a processor in a safety compliance facility to basically manipulate industrial hemp. And it's yet to be seen how the new marijuana regulatory agency is going to basically allow these laws to interact. So there's a lot of unknowns still, and obviously these things will be fleshed out. And we'll continue to keep you informed as industrial hemp has its impact on marijuana and vice versa. Another topic that's kind of up in the air right now is what role will a municipality have for industrial hemp? That's, quite frankly, it's hard to say right now. Some municipalities might not want industrial hemp in their communities, and there are ways that, as a local municipality, they have ways to attempt to make that be the case. So as that develops, we'll have to see what the Michigan townships and cities and villages do should they try to take the stance that they don't want to allow industrial hemp cultivation. All of that should be certainly exciting over the next several months.
Yeah, and without opening a whole can of worms here, I think this is a really interesting issue because if you followed the cannabis industry in Michigan and the cannabis laws, many of you might be aware of how the MMMA caregiver grows were treated in various municipalities. Some of them welcomed them with open arms. Other ones completely banned it in contravention to state law. Sorry, it's Friday afternoon. It's a little bit tricky with my words here, but in contravention,
good morning.
Right, in contravention of the state laws. So at the same situation here where there's a state law that says you can do something, they've given you a license that says you can do something. It's a question though, and it's not contained in the law or contemplated as far as what do the local municipalities have a say on? Some neighbors might complain that these cannabis plants smell still, yet you're farming it, and they might claim it's a nuisance. As Travis mentioned, the Right to Farm Act protects certain farming activities, but only if they're generally accepted agricultural and manufacturing practices. Due to the federal illegality of cannabis and hemp, there haven't been generally accepted manufacturing practices pertaining to these plants. And so, on the one hand, the state law is going to allow it. On the other hand, there's going to be rights for your neighbors to enjoy the use of their property without nuisances and odors. And land use and zoning comes into effect, whether a industrial hemp farm is a permitted use. So there's a lot of interesting legal issues that still need exploring here. Hopefully, MDARD will guide municipalities in terms of how they're supposed to react to these specific scenarios now that they are kind of jump-starting the pilot program starting early as next week. So as soon as those processor handlers and growers get their registrations and their licenses, they're going to be wanting to plant the seeds and get growing because the growing season is starting soon or might have already started. And it's to be seen what those local communities are going to actually react. And it would be my hope that they would be more welcoming to the activity and the land use occurring in their jurisdictions based on the fact that it is federally legal and there's avenues for these types of businesses and individuals to actually plant their seed in the ground, pun intended, and get going with the good graces of Michigan.
Exactly. So that's going to do it for us this week. Thank you so much for joining us this afternoon. I hope you all enjoy the holiday weekend, whatever you celebrate. We all know that tomorrow's a big day. If anyone's going to be in the City of Bangor's 420 Festival, I will be joining you there Saturday around noon, so come say hi. Everyone have a safe weekend, and we'll catch you next week. Thank you so much.
Bye.